A Supreme Court decision just dropped, and most people talking about it are getting it wrong. Not slightly wrong, not technically wrong, dangerously wrong. And if you repeat the wrong take online, if you build your understanding around a viral headline instead of the actual holding, you could make decisions that hurt your rights instead of protecting them. Let me ask you something before we go any further. Are you subscribed? Because what we're about to walk through today is not surface-level commentary. This is the kind of legal shift that quietly determines who ends up free and who ends up facing federal charges. And misunderstanding it could cost someone years, even a decade, in prison. So hit subscribe now, because the internet moves fast, but federal law moves permanently. The viral headline. You've probably seen it already. Breaking. Supreme Court 8-1. Decision just changed First and Second Amendment rights. That headline is technically tied to real events, but it's mixing two different lanes of law, two separate constitutional fights, two different cases. And when people blur them together, confusion spreads fast. Today, I'm going to untangle it. By the end of this video, you'll understand what the real 8-1 Second Amendment decision actually held, what it did not hold, how the First Amendment is involved, but in a separate fight. What this means in real life if you deal with restraining orders, speech issues, or government pressure, and what mistakes could put an otherwise law-abiding gun owner into federal felony territory. Because here's the truth. Most people don't lose rights during dramatic moments. They lose them during paperwork moments. Segment 1. What actually happened in the 8-1 Second Amendment case? The case is called United States v. Rahimi. This is the real 8-1 decision everyone is talking about. Here was the core legal question. Can the federal government temporarily prohibit someone from possessing firearms if that person is under a domestic violence restraining order, and a court has found that person poses a credible threat to another's physical safety? The Supreme Court said, yes, that's the holding. If a court finds that you are a credible threat to someone's safety, the government can disarm you while that order is active, and doing so does not violate the Second Amendment. Now stop, breathe. Because here's what the court did not say. They did not say, the Second Amendment is gone. Accusation equals disarmament. Anyone accused of domestic issues automatically loses rights. States can disarm people just because they feel like it. This case is about a very specific type of court order, with specific procedural requirements, with a specific finding, credible threat. That phrase matters. Because online, people are acting like the court just approved broad gun bans. That's not what happened. Why this case is bigger than it looks. To understand why Rahimi matters, you have to go back to another case. New York State Rifle and Pistol Association vs. Bruen. You've probably heard it called Bruen. Bruen changed how courts evaluate gun laws. Before Bruen, courts often used a balancing test, weigh public safety versus gun rights, like a scale. After Bruen, the Supreme Court said, no more balancing tests. Instead, courts must look to history and tradition. If a modern gun law is consistent with America's historical tradition of firearm regulation, it can stand. If it isn't, it falls. Sounds simple, right? It wasn't. Because lower courts started fighting over what history and tradition means. Some judges began demanding almost impossible proof. Show me a law from 1791 that is exactly like this modern law. A historical twin. Not similar, not analogous, identical. And that's where Rahimi stepped in. The historical twin problem. In Rahimi, the court basically said, stop. The Constitution is not trapped in amber. That phrase matters. The Second Amendment is not frozen like a bug in a block of ice from 1791. You don't need a perfect historical twin. You need a historical analog. Analog means similar in principle, close enough in the important ways. The court explained that judges must look at the why of the regulation, the how of the regulation. Why does it exist? What danger is it addressing? How heavy is the burden? Is it temporary? Is it targeted? Is there due process? That's the new battleground. And this is huge, Because Rahimi isn't just about restraining orders. It sends a message to every lower court in America. You cannot demand an exact replica from the 1700s. You must look for comparable principles. That affects every major Second Amendment case moving forward. Permits, carry restrictions, sensitive places, prohibited person categories. All of it. Make it real. The Mike scenario. Let's make this practical. Meet Mike. Mike is not a felon. He's not in a gang. He owns firearms legally. He carries legally. But he's going through a nasty breakup. His ex files for a protective order. Mike thinks, this is family court stuff. It's civil. It's just paperwork. It'll blow over. That's the mistake. Because if that protective order includes a judicial finding that Mike poses a credible threat to someone's physical safety, and if the order meets federal statutory requirements, Mike can become a federal felon simply by possessing a firearm while that order is active. No new crime, no arrest for violence, just possession while under a qualifying order. Temporary can mean handcuffs. Temporary can mean thousands in legal fees. Temporary can mean permanent consequences. That's why you cannot treat restraining orders as drama. They are legal triggers. Why the 8-1 vote matters, Rahimi, was decided 8-1. That's not a narrow ideological split. That's overwhelming agreement. Only one justice dissented. That tells you something important. The court does not view this type of temporary disarmament, tied to a judicial credible threat finding, as outside American tradition. And here's another key detail most people miss. Rahimi was a facial challenge. That means the defendant wasn't saying, this law is unconstitutional as applied to me. He was saying, this law is unconstitutional in all applications. That is the hardest type of challenge to win. To succeed, he had to prove the law could never be valid. The court didn't need to decide every hypothetical scenario. It just had to decide whether the law is constitutional in situations like his, and it said yes. That keeps the ruling narrower than viral commentary suggests. Segment 2. Where the First Amendment comes in now, let's shift lanes. Because the First Amendment portion of this headline is real, but separate. Rahimi was not a First Amendment case. The First Amendment issue comes from a different line of Supreme Court cases involving government pressure and speech. One major recent example is National Rifle Association via Vullo. That case dealt with whether government officials can pressure private companies, like banks and insurers, to cut ties with organizations the government disfavors. Here's the simple version. The government cannot use indirect pressure to punish lawful speech. It cannot threaten regulatory consequences behind closed doors in order to silence advocacy. And that matters deeply in the gun world. Because sometimes, instead of banning something outright, pressure campaigns work like this. Banks' close accounts insurance gets canceled. Payment processors drop service. Platforms deplatform vendors lose coverage. No law passed. No vote taken. But speech gets squeezed. That's a First Amendment problem. Why gun owners should care about the First Amendment. Many gun owners say, I only care about the Second Amendment. But here's reality. The First Amendment is the engine that defends the Second. If you can't speak, you can't organize. If you can't organize, you can't fund lawsuits. If you can't fund lawsuits, you can't challenge restrictions. Speech and arms are connected, different lanes, but they collide in real life. 5 big takeaways so far. 1. Credible threat is a legal trigger. It is not just a phrase. If a court makes that finding, federal firearm restrictions may apply. 2. Due process matters, but you must participate. Notice and a chance to be heard are critical. Ignoring a hearing can create the very result you fear. 3. Temporary can still wreck your life. Even short-term disarmament can mean permanent legal consequences if violated. 4. Bruen still controls, but Rahimi clarifies how. Courts must use historical analogy, not demand perfect twins. That reshapes the fight. 5. The First Amendment is not optional in the gun debate. Government pressure on speech is a constitutional line, and the court reinforced that limit. The bigger warning. Here's something that might frustrate people. If you're a gun owner, you have to be the calmest person in the room when conflict starts. Not because you're weak, because you have more to lose. The legal system treats mistakes involving firearms differently. The same bad decision, when paired with gun possession, can escalate consequences dramatically. The law doesn't care that you're usually responsible. It cares what was filed, what was ordered, what you did next.